Okay, we're going to continue on with our discussion of parental rights and responsibilities and child support, but we're going to now do it in the context of children who are not born as issue of marriage, children who are born outside of wedlock. In your text, this is going to be chapter 9 of the book. So far we've been talking about domestic relations court or family court. We've been talking about the rules that are set in place for children and for in the context of a termination of a marriage. What are we going to do with these children, right? And so in the context of a marriage that's terminating, either with a dissolution or a divorce, either contested or uncontested divorce, there's always going to be either a separation agreement that everybody's agreed to or an order of the court. Okay? And always, if there are children involved, the court, the judge, makes sure that those children are taken care of and has an order put in place concerning where the child lives, where the child goes to school, what the visitation is with residential, non-residential parent, or if there's a shared parenting plan, all of the statutory things that need to be covered in a shared parenting plan, and that there's a child support order that's put in place that is going to go through the Child Support Enforcement Agency, and that we have those enforcement mechanisms in place in case they don't pay child support, or in case we have problems with our visitation or our parental rights and responsibilities. Okay? So in the context of a divorce, all of that is set forth in statutes, in laws that the legislature's put in place. And therein, the divorce section of the Ohio Revised Code, or whatever code of whatever state you're talking about. So what do we do with children that are born outside of marriage, where parents are not terminating a marriage? What do we do with those children? Well, a little history. Up until about the 1970s and 80s, are you seeing a theme here that the world kind of changed then? 1970s, 1980s, we didn't do anything. There wasn't child support, there weren't parenting rights, there was barely maternity tests. Actually, for children who were born outside of marriage, on their birth certificate it would say bastard. And when the 1970s hit and women were divorcing their husbands and the world was going through the era of new love and children were being born outside of wedlock, and with the intervention of government into people's domestic lives, basically paying for housing, paying for food, kind of fulfilling the role of the husband in a marriage, we had a lot more children born outside of wedlock. And a lot of moms said, wait a second, my neighbor's divorced and she gets child support. How come the father of my child isn't being made to pay child support? He's just as much a father as my neighbor's ex-husband is a father. And we really shouldn't be doing things on the basis of a marriage license. We should be following the best interest of the child and recognizing that fatherhood can happen outside of marriage and do something to help these children. Well, that was a persuasive argument. And the legislature said, yep, we are on it. And where were they going to put this new set of laws that have to do with child support, visitation, paternity, all the things that you need to do for children who are born outside of marriage? You couldn't put them in domestic relations court because you need the golden ticket, which is a marriage certificate, to get in there. You don't have the golden ticket, can't go in. And it was going to be a heck of a lot of work rewriting all of those laws for domestic relations court. So in Ohio, what the legislature did was said, okay, counties, if you want to create this family court that is all encompassing for people who are terminating marriage and have children, as well as for children who are born outside of wedlock, have at it. We're giving you carte blanche to go ahead and restructure your county courts to do that. And for those county courts that don't want to do that, you already have a juvenile court. And children are juveniles, so let's try and kind of fit this square peg into a round hole of juvenile court. Because originally juvenile court was set up for a special criminal court for children who needed guidance and needed help with rehabilitation and sometimes needed to be removed from society. That was the original intent of juvenile court. We then expanded it to making sure children were safe. That became a larger mission goal for juvenile court, which includes things like, okay, if a child is being abused or neglected, well then they're not safe, and so we're going to bring that kind of action in juvenile court. Or if a child is born out of wedlock, that wasn't their choice, and so they should be entitled to a relationship with their father, and they should also know who their father is, and they should also have the benefit of child support from that father. And so within that broad umbrella, most juvenile courts expanded. In Mahoning County, you have a juvenile court. In Trumbull County, you have a family court. Two counties right next to each other who kind of viewed the situation differently and addressed it differently, both within the confines of the statutes that were put in place to try and take care of children who were born outside of wedlock. Okay? So there are some differences with what we do with children who are born outside of wedlock with respect to paternity and establishing child support and then visitation. And by the way, it goes in that order. So if you have a child who was born outside of wedlock, mom is the sole custody of that child, has sole custody of that child, period. Father has zero rights to that child. Father, and I don't care if father signed the birth certificate at the hospital, father has zero rights to that child, period. If father wants to have a relationship with the child, and by the way, why is that? Well, we always know who mom is, right? Baby comes out of mom, that's an easy one. We don't always know who dad is. I think Maury Povich is still doing shows on Are You the Dad, right? Sometimes there's a question. So what we do is we make sure that we know who mom is, we know mom is caring for the child, that mom has sole custody. If dad wishes to have a relationship with the child, dad needs to go to juvenile court or family court and petition for paternity. Dad has to say, I'm the dad, and undergo a paternity test. Now, sometimes this is done at the hospital, trying to cut through, especially because lots of times the government is paying for the birth of the child, and for, the prenatal care, the postnatal care for mom, and for the baby. And the government says, we know we did not get mom pregnant, but we're paying everything, and so we need to find out who dad is so dad can pay us back. That's the government's perspective. By the way, lots of times you kind of have a trio of mom, dad, and the government because the government would like reimbursed. Okay? So, dad needs to file for paternity if paternity has not been established at the hospital through a paternity test. And what will happen in, I'm just going to say juvenile court, but it could be family court. In juvenile court is a magistrate will be assigned to that particular case. And remember, a magistrate is just an unelected judge that kind of handles the everyday grunt work in the court to free up the judge for the bigger cases. So the magistrate's going to order a paternity test and then say, come back. Okay, so you come back a month or two later, you're dad. Congratulations, have a cigar. Now you have to pay child support. Without question. You are dad. We now do the same child support guidelines worksheet that we did in a divorce, where we merge mom's income, dad's income, put them together. If dad's income is 50% of the calculation of the total income, then dad's going to pay 50% of whatever the child support guidelines are. Okay? Great. So now does dad get to see the child? No, not unless mom wants to, because mom still has sole custody of the child. Remember, alimony used to merge spousal support and child support. We split that up and added child support and visitation. And so we now have all these separate entities and all these separate hoops you have to jump through. So now dad has established paternity, come back a couple of months later, then had child support, and now has to file what's called a motion to establish parental rights and responsibilities. You mean you've got to ask the court specifically? Yes, you do. Okay, it is different from domestic relations court or divorce court because you've got the presumption that if a child is born during the course of a marriage, it's as issue of marriage. If a man says, look, that's not my baby, you can go through the test, but 9 times out of 10, that's your baby. You're going to pay for child support. Remember, you can't have a final divorce hearing, dissolution hearing if you're pregnant, because we have to know who dad is. Okay? Knowing who dad is the first question that gets answered. And in juvenile court, we do that, but we don't merge together paternity, child support, and parental rights and responsibilities. They're done separately. That could take a year before you even get a hearing on parental rights and responsibilities. And dad will come forth and say, look, I'd like to know my child. Many, many, many times, dad has never spent any time with this child. Maybe the child was born. Mom said you can come over and visit, but not much. Has never taken the child anywhere, has never had the child sleep at his home. So this becomes a problem. Just like we have transitional orders in domestic relations court where we've had a lapse in time for the child being with the absent parent, we use a lot of transitional orders in juvenile court. And again, that's because most of the time, especially with small children, dad doesn't have any kind of relationship at all with this child. And so a typical transitional order will be something like, okay, for 4 weeks, you will go to mom's house and visit with the child once or twice a week. And then for 4 weeks, you will be able to take the child once or twice a week to a public place, or maybe to your home, but it's only for a couple of hours. And then for another 4 weeks, you can take the child for a longer period of time, but not overnight. And then after, 8, 12 weeks, come back, right? Now we're at 3 months since the order goes in place, and report to the magistrate how things are going. Things are going well, things are not going well. Do we need to have a guardian ad litem appointed? What's going on here? So you go back to court, and dad will say, I think everything's going okay. Mom might say, I don't think so. We might have a discussion. Maybe a guardian ad litem gets appointed. And, but hopefully, we progress to the point where we kind of get to a standard order of visitation, where the child will go with dad one weeknight and every other weekend. And then we'll trade holidays. And now, obviously, if you're dealing with an infant, this can be a problem, right? What if you're breastfeeding the child? Well, what most courts say is express milk. If you have, a really small baby, or a baby that is not on formula, it becomes kind of a challenge. It's a challenge on dad's end too, because dad is going to have to show that he has adequate diapers, formula, milk, crib, a safe environment for the child. All of this has to happen. And if you're a guy and you find out you had a baby, sometimes it takes you a little time to get all that stuff together. So it's a little bit more complicated in juvenile court with unmarried parents than it is in domestic relations court with married parents. You have more hoops to jump through. By the way, each one of those hoops costs money. So if I'm dad and paternity's been established, typically that doesn't cost too much money. Now I have to pay child support, and I'm probably already in arrears, right? Because child support's going to go back to the date that the child was born. Now, if mom played a game and said this isn't your child, there are arguments that can be made that it wasn't reasonable for dad to think that they had a child, and sometimes the court will backdate only to the date that the hearing was held on child support. But if you were at the hospital and you got a paternity test and you knew that you were dad, that child support's probably going all the way back to the date of the birth of the child, which means you're already in arrears. You're already in a heap of debt. You thought I was going to say something else, didn't you? You're already in a heap of debt. Now, I'm having money taken out of my paycheck. Now what? Now I have to pay a lawyer and schedule a time with the court so that I can fight over the next 12 to 16 weeks at a minimum to get an order put in place for me to visit my child. And I'm going to have to pay a lawyer for the hearing we're going to have in the middle of it. I'm going to have to pay a lawyer. I'm going to have to pay a lot of money. And there's a filing fee, by the way. This is not an inexpensive proposition. If you wonder why a lot of dads don't see their children, this is one factor. Now, it's not the only factor. There are a lot of people who just don't want to be involved with their children's lives. Okay? There is that. But it's an expensive deal to go through juvenile court. It just is. Now, a lot of these are children who were born out of wedlock, for people who are just irresponsible in procreating. Some of them are boyfriend, girlfriend who've lived together for forever and have had a child, kind of did things in the wrong order. And those cases can have other complicating factors like, I hate you. It's almost like a divorce without the divorce. I hate you. You did X, Y, and Z, and I don't like you anymore, and you can't see the child anymore. And by the way, I'm the mom, so you don't have any rights at all. Juvenile court has to deal with those cases too, where there's a dad who has been involved with the child, just that they haven't been married, and mom says, sorry, I got sole custody. Goodbye. Happens. In those cases, a guardian ad litem will be appointed to represent the interests of the child, and hopefully the court moves those hearings along a little bit more quickly, but the system is what it is, and it doesn't always work that way. Okay? All right, your book has some sample statutes in it. Again, I'm going to have you look up Ohio's statute, especially where it comes to child abuse. That's what we're going to focus on here too. But if you wish to read through some of those cases. Another thing that juvenile court does, and remember, the umbrella is keeping children safe, even in criminal cases, right? And just as an aside, when we're dealing with juvenile criminal cases, the goal of the state is to rehabilitate the child. That is the only goal of the state. Okay, yes, there can be, the child may have to pay back for damages or whatever, but the ultimate goal is to take that child, rehabilitate them so that they can be functioning adults in society. Okay? We're trying to take care of children. The state has a legitimate interest in making sure that children are protected and cared for, which is where the child protection laws come into place. And that's why we do it in juvenile court. So your book talks about the Child Abuse Prevention and Treatment Act of 1974, which was a federal act that gave some guidance to states about what to do with suspected child abuse. Okay? How do we define what is abuse? I'm going to tell you right now, it's a really low bar. It's really, really low. The standard is the child abused or neglected? Okay? Now, what is neglect? Let's take that one first. Things like, for babies, not having clean diapers or formula, or being left in a crib all the time, being given juice bottles that rot their teeth. Those are neglect. The child is left alone before it's an age where it's appropriate to leave children alone to take care of themselves. There's no food or adequate food in the house, or an adequate place designated for the child to at least sleep. Those are neglect. Abuse is, and this has been a sliding scale over the years, some kind of permanent physical harm to the child. When I was growing up, kids got spanked all the time. I got spanked. Everybody got spanked. Okay? And then the pendulum swung in the 1970s and 80s, and yes, I'm dating myself. 60s and 70s, you can't spank your child, that's abuse. And people were actually prosecuted and children removed from their homes for abuse and neglect, for spanking. And then the pendulum swung back and a little bit, and you weren't allowed to use any object to spank your child. A lot of kids I grew up with had a paddle or a belt, right? And that's what you got your spanking with. And then it kind of went back to, it can't leave permanent, you can't permanently injure your child or use some kind of something other than your hand. And that's kind of where we've settled. It is one thing to spank your child, it is another thing to beat your child, and there is a distinction between the two if you leave a mark. Okay? Now, I'm going to tell you, this is a sliding scale and it changes all the time. Today, we have lots of abuse issues with drugs, where children are exposed to fentanyl, heroin, whatever, whatever the drug du jour is, and they're put at risk, or they actually do ingest some of the drugs. I will tell you that marijuana is kind of off the chart of that right now. I actually had a case once where I represented the grandmother who had custody of her grandson. And we'll talk about temporary orders of custody in just a second. But the reason why she had custody was there was an abuse and neglect order because the child's mother was a stripper and there were drugs in the house. And the mom and the dad had to be drug tested regularly, and they came back positive for pot. And I told Grandma, well, they failed the drug test. And I went to the hearing, and the judge said, sorry, it's just pot. They didn't fail the drug test. And by the way, that was a few years ago. So things have really changed. What the court does if they find that there is abuse or neglect for a child is they remove the child from the home. Different states have different names for the agency that then takes temporary custody of the children. It's Child Protective Services or Children's Services. You'll hear those phrases, Child Support or Children's Services Agency or Bureau. And what happens is, because the state has a legitimate state interest in protecting children, the state, through that agency, can remove the child from the home and then go to court and ask for temporary custody of the child. Why do we call it temporary? Well, we can't have permanent custody because the child's going to turn 18 and then the child is going to be an adult, and so this is only temporary. Boy, that sounds like a long time if you're removing an infant, right? But temporary can span 18 years. So the state takes temporary custody. Now, in the old days, we had orphanages and children were put in orphanages, but now we have foster parents, or the first thing that Children's Services or Protective Agency does is tries to find a blood relative to take the child, grandma. Or if mom is neglecting, then dad. We try to find somebody who can keep the child's world stable. And you would assume that if grandma can keep the world stable, then you're still within the same family unit. Okay? Problem is, lots of times grandma's pretty unstable too. So sometimes that's hard, and so the child gets placed in foster care. This needs excuse me. The goal, while the child is removed from the parent's home, is to reunite the child with the parent. It is not to keep the child in the temporary custody of the state forever. Instead, what Children's Services or Protective Services does is counsels the parent on how to get off drugs, how to have a safe home, how to make sure the child grows up in a safe environment. And again, that's a really low bar. Really, really, really low bar. We're not looking for the child having their own bedroom. We're not looking for, 3 good meals a day. We're looking for some food. We're looking for a place to sleep. Pretty low bar. But the parents have to go through a parenting process. Generally, it's a checklist. And once the parent goes through that checklist and thinks, hey, it's time for me to get my kid back, they have to petition the court to go back and to revoke temporary custody and get custody returned to the parent. Okay? It's not an automatic thing. Not an automatic thing. So, if the parents cannot fulfill the parenting program, then the state may try to place the child permanently, give permanent custody or transfer temporary custody to another adult in the family, or in the case of a child that's in foster care, have that child put up for adoption. Now that takes a termination of parental rights. That's a hard thing to do. The courts don't like that. There is an innate right of parents to raise their children. And just because the state doesn't agree with certain things They can't keep the child from the parent. It is only when the child's safety and welfare are at risk that the state has the right to take the child out of the home. So if a parent comes forward and says, I think you really don't want me to have this child because I'm a stripper, which is not illegal, and I've done everything else on the list, you got to give me my kid back. And the courts will generally agree with that. It is a tough thing to do to keep parents away from their children. Typical cases where that will happen will be parents are in jail for 20 years. Let's say the sentence is 20 to 25 years. Well, okay, there's no benefit to the child because you're going to be completely absent. If there are persistent drugs in the house and it's been going on for a long time, and parent keeps getting arrested or going in and out of rehab, if there is sexual abuse, that's the biggie. If there's been sexual abuse of the child, that parent is going to lose custody permanently. And then that child is going to be able to either be placed with a relative permanently or put up for adoption. Okay? Parents can willingly sign away their parental rights. Unfortunately, this happens a lot. Lots of babies who are born with fetal alcohol syndrome, AIDS, addicted to drugs, and that their child is going to have mental and physical issues later on in life. Parents are like, I don't want that kid. And they sign away their parental rights. And those children become wards of the state. And then are placed with either family members or foster care and hopefully put up for adoption. Okay? It's an awful process. It's terrible. It's where you see families in the ultimate distress and children who need the most care shoved into a system that is tough. It's a tough, awful system, the foster care system. And the older the child gets, the tougher it is to adopt the child. The more likely it is that child will stay in foster care forever. Okay, what do we do if we have other kinds of abuse and neglect issues or violence in the home? This is done with not just families that have children outside of wedlock, but also where you're married. We have these things called civil protection orders, CPOs, where if you have a child with someone or if you are married, you can go to the court and you can say, look, I need protection because he or she is threatening my life, either with a gun or knife, and it's an imminent risk of harm. And I'm afraid. And so this person needs to be restrained from being around me. I need to be protected, a civil protection order. Now, this is different from a restraining order, which is a criminal animal. This is a civil thing. It has the same kind of penalties as, say, a restraining order does in criminal court, but we do it civilly. And one of the reasons we do it civilly is because we have a little bit more leeway with time with these things. If I go to the court and I say, the father of my child, even though we're not married, is threatening me, the court can grant me a CPO, a civil protection order, today. The man doesn't have to even know that I'm down there and his rights have been affected. That is called a temporary restraining order. It's only in place for a maximum of 14 days. And then after 14 days, the court has to hold a hearing and the person that I'm accusing has to have the right to come forward and defend themselves. Okay? And then the civil protection order can either be expanded for another period of time up to 2 years, or the court can say, you know, Diane, I think you were making up a story, and no more civil protection order. Okay, so a civil protection order can be used not only for people who are not married. The standard is you have to have a child that together if you're not married, or if you are married. Okay, if you're not married, that standard is that you have a child together. Okay, now there are criminal cousins of the civil protection order, domestic violence laws, right? So I could choose one or the other, or both. I can go and get a civil protection order, and then I can go to my county prosecutor or my police department and say, look, we've got domestic violence going on here. Can you please prosecute them? And you can have both things going at the same time, or you could choose one or you could choose the other. But in the context of the civil court system that we're talking about with domestic relations and with the juvenile court section that we're focusing on right now, the civil protection order is what we're talking about. Okay? And remember, this is called an ex parte hearing, Latin phrase of the day. Out of, away from the person you're accusing. And I can affect that person's rights immediately. We have to have a hearing within 14 days, but immediately you can change the locks on the house. Sorry, you can't come in here. I have a civil protection order. Go away. You can't text me. You can't call me. You can't send me emails. You can't come to my house. You can't wait outside my house in your car. You can't come to my job. Go away. And that is where you can show there's imminent risk of physical harm to you. Okay? All right, so that's it for this chapter. I'm going to have you look up a CPO, by the way, and just see the standard for it. And I'm also going to have you look at a paternity, a motion for establishing parental rights and responsibilities with a transitional order. I want you to get a flavor of that because that's very, very different from domestic relations court, where in domestic relations court, it's assumed dad is going to have visitation, period. In juvenile court, not so much. Again, we know mom, we don't know dad. And we got to make sure that this kid is safe and we're doing what's in the best interest of the child. So, look for your assignments for this. This will be week 11, and this will be posted. So if you have any questions, give me a call or an email. Thanks.